guidance that moves lives forward.
Hi, I'm Wendy, and my co-host Daniel and I are talking about why divorce doesn't suck. Our podcast is all about the life you can live and how you can thrive after divorce. You'll hear regular people's stories of divorce and how they reinvented themselves and grew after divorce. You will also hear from experts in the field of marriage and family, sex and relationship coaches, lawyers, and so much more. You will learn lots of great tips on dating from both people who lived it and thrived, and also dating coaches who will share their advice about how to get it right and also how to have fun. We get real here at Divorce Doesn't Suck. Join us in this conversation and the community we're building to help heal and thrive after divorce, because really, divorce doesn't suck. Welcome to another episode of Divorce Doesn't Suck. I'm Wendy Sloane with my co-host Daniel Harold. Hello, Daniel.
How are you?
I am well. I cannot believe this is our 8th of our 12-part series, Mapping Your New Path Forward with attorney Melissa Needle. How did we get here?
Know her. We live in her living room.
We live in her life. And the one thing that I have to say that I've learned a lot about so much, like we've talked about this. This is like a book. Melissa needs to write a book because this is such a guide for people getting divorced, thinking about divorce. Even afterwards, there's a lot of thought in what we talk about after. But Melissa, she helps her clients negotiate and develop a plan for the rest of their life. It's not just about, the dissolution of a marriage. It's more than that. And her clients are more than that to her too. And we've felt that, and we've heard that through this entire series. I mean, she's been in family law for so long. She's a 3rd generation lawyer, deep roots in Connecticut, where I live. So
keep the compliments coming, Wendy. I love it.
I can't.
It's a wonderful way to spend my time with you.
Yeah.
But Daniel, isn't it true? I mean, it's like you don't, when you think about an attorney and you think about all the stuff that goes on, especially in divorce, you just have such a calming way about you, and you do care.
Attorneys are intimidating, I think, for a lot of people. Because they just go in.
I get that a lot. When people come into my office, they're very nervous. And then when they leave, they say, "Oh, I didn't need to be so nervous. I'm glad that I met you. I feel so much better." And I think the reason for that is, and I appreciate your compliments about my demeanor. And I do think that has something to do with it. But I think the other important thing is that if you can arm people with information so that they can put their situation in context, it really does ease anxiety. Because one of the scariest things about getting divorced and going through this process is the unknown and not knowing what impact your decisions will have on your family and your future. And that's scary.
It is. The whole process is scary, but you make it... You help us to understand it, which is, takes away some of that fear too.
Right.
So
information is power, right? It's a funny story of this. I was just thinking of this, Melissa, when you said that. My daughter's graduating and she got a job. And she's graduating from college. And so I said, we need to sit down and do a budget. And she's been avoiding the conversation for a couple months. And so finally I was in Nashville. We sat down and I could just see the anxiety just written all over her over breakfast. And I said, okay, this is going to be a lot easier than you think. And we just kind of walked through it, and just to be filled with that information, like, oh, I can afford to live. It was incredibly empowering for her. But, you're right. When you don't know something, if you don't know what the process is going to look like, and you hear all the horror stories, you're going to have a lot of anxiety going in. And to have a calm and soothing demeanor, and to have all the information at hand that you can talk about, is really a great way to set the stage for a client.
Yeah. I think it's really important for people to, and they're not going to understand everything all at once. Rome wasn't built in a day. Yeah. But if you can at least assuage their initial fears and tell them that they're going to be okay, and it really does help ease the anxiety, like I said.
So let's get into it. So it's our 8th of our
Okay.
12-part series, Mapping Your New Path Forward with attorney Melissa Needle of Needle Cuda Divorce and Family Law. We're talking about today depositions and expert testimony, what they are, what they mean, and so much more. Welcome back, Melissa.
Thank you, Wendy. Thank you, Daniel. It's always a pleasure to be here. I love talking to both of you, and I love informing the audience about little segments of the divorce process.
And we are doing that, and we have done that. So depositions, I find them interesting.
Now, this would give most people anxiety, right? Depositions.
Yeah, depositions are a very important part of the divorce process. I mean, not every case requires depositions, but quite often depositions are required. And I want to start out by telling you, the audience, really, what a deposition is, because I don't want to assume that everyone knows. And a deposition is when a lawyer asks a witness questions in a office or conference room, and there is a court reporter who is transcribing, and when I say transcribing, they're typing all of the questions and all of the answers. And the answers are all given under oath. So at the beginning of the deposition, the witness has to raise their hand and swear under penalties of perjury that they're going to tell the truth. And so it's a very formal process in regard to the answers that are given are under oath. And so in that regard, it is very serious. But it is less formal than being in the courtroom in front of a judge. So it's sort of the in-between. It's not as if you're just having a conversation, but it's not as if you're in the courtroom in front of a judge. It's in the middle. And that's what a deposition is. And you could take the deposition of anyone who you think will give you information that will help plan out the evidence that you need to present in court or for purposes of settlement negotiations. So, that is what a deposition is. And then the question then becomes, whose deposition do you want to take? And typically, you will take the spouse's deposition. So if I represent a wife, for example, I will take the husband's deposition. And there are a number of different reasons that I like to take a deposition. And I always talk about this with my client in advance because I want to manage their expectations. Sometimes I take a deposition because there's real information that I need to understand and ascertain. So, for example, if I'm taking a husband's deposition and he has a job in some sort of industry or at some sort of company that I don't fully understand, or there's components of his compensation that need further explanation, for example, a forgivable loan or performance stock units or restricted stock units, or carried interest. I mean, there's a number of different reasons that you want to take the deposition. And oftentimes you want to understand about a party's compensation. You might also want to ask about the cause of the breakdown of the marriage. What happened from their point of view? I typically ask, what are your spouse's positive and negative traits? I want to get an understanding of what their strategy or theory of the case is going to be so that I can then defend against it. So you take a deposition because there is specific hard information, like what is your educational background? What degrees do you hold? What is your work experience? What is the highest salary that you made? What is the reason that you left this job and went to that job? That's kind of hard information, or that's how I describe it. And then the softer information is, what are they going to say about the case, about the touchy-feely aspects of the case? Why did the marriage break down? How is your spouse as a parent? What attracted you to each other initially? You just want to get sort of a feel of what the relationship was like from the spouse's point of view. And that's going to be very important when you're trying to formulate how you're going to present the case if you ever go to trial.
So you're like kind of mapping out a narrative for what's going to go.
Exactly. It helps, you know what your client's narrative is going to be. Mm-hmm. So when you take a spouse's deposition, you're trying to understand what their narrative is going to be so that you can either defend against it or, make sure that you are prepared to answer certain issues that may present from their point of view.
Would there be other people you would depose in a deposition in a divorce besides the husband or the wife?
Yeah, but before I get to that, I want to explain. So I said there's a couple reasons that we take depositions, and one is to elicit information. The other reason that I sometimes take a deposition is I want to see what type of witness the spouse will be. Are they a good witness? Will they answer questions succinctly? Will they talk on and on and on? Are they angry? What is their body language going to be like? You learn quite a bit when you take a deposition about the type of witness a person will be. And that's really important, because when you go to court, judges not only listen to the information and evidence that's being presented, but they also observe each of the parties. And if someone is a really good witness or sympathetic witness, then that is going to have an impact on decision making about whether or not we're going to proceed to a trial or a hearing. So that's really the other reason that I take a deposition. And you can pretty much take anyone's deposition. You could take, of course, the spouse's deposition in a divorce action. You can take a lover's or paramour's deposition if you think that's going to be relevant to the issues that present in your case. You could take an accountant's deposition. You could take a mother or father or sibling's deposition if you think that's going to be important. You could take a teacher's deposition if you think that's going to be important. If there is a guardian ad litem in the case, it's very important that you take their deposition to understand what their opinions and recommendations are going to be and why. So it's kind of like the world is your oyster. I have had clients request that I take depositions of children, even if they're adult children. I don't do that. I don't think it's fair to the child. I mean, if the child is, 50 years old, it might be a different story. But if the child is, 23 or 24, I won't do that. I just don't think that is fair. But it is something that can be done if a person thinks it's critical to their case. So the world is your oyster when it comes to who you want to depose. There can be limitations with regard to the reasons that you want to take the deposition. If you're taking a deposition just to annoy, embarrass, or harass, then the court may not permit that deposition to proceed. But for example, I've taken depositions of au pairs who have lived within the family unit, who have firsthand observations of how a spouse parents children. And I have taken the depositions of all sorts of different professionals. So depending on the issues, you can take anyone's deposition.
Mm. How do you prepare your client for the deposition?
Say that again.
How do you prepare your client for the deposition?
Okay, so when my client is going to be deposed, it's very important that we spend a lot of time preparing for the deposition. I think a lot of lawyers overlook this. And the reason it's so important is because everything that your client says at the deposition is transcribed under oath. And so there's a record of it, and you can't change your mind after that. You are sworn to tell the truth. So the answers that you give cannot be changed. And so you have to be very thoughtful about preparing your client for their deposition. And what I do is I first talk generally about the narrative that we want to tell. And if they understand the narrative, then I feel that they are more capable of answering questions that support that narrative. And I will also take time to ask my client questions. We do like a pretend I'm the lawyer and you're the witness. And I will ask questions that I think the other lawyer will be asking, because I want to understand how they are going to answer.
Right.
And then we'll talk about how they answer. And I will tell them what I think is good and what I think is bad about it. And, the client has to use their own words, and it's their story, and they must tell the truth. That, of course, is critical. And at the same time, I just think it's really important for them to understand what it is they're trying to communicate from a very high level. And if they have that understanding, then when the questions are drilled down to more detail, they are more likely to answer in a way that supports the narrative, the theme, the strategy that we are presenting. So it's really important that a client spends time with their lawyer being thoughtful about the deposition. And it's important for them to practice. They need to understand the setting. I often go into detail. You will be sitting in one spot. I will be sitting next to you. The lawyer who will be asking you questions will sit across from you. I tell my clients, if you need a break or you feel nervous, just tell the lawyer who's taking the deposition and you'll be able to take a break. So getting into details about what will happen. I tell them, don't bring any notes, don't bring anything with you, because a lawyer can say, what is it you're looking at? I'd like to see what you're looking at. And it could be very awkward and uncomfortable. So better off to have no notes in front of you. Don't offer, oh, well, I have that contact in my phone. Would you like to have my phone?
They can take your phone.
I have that happen quite often. So you have to go over these rules with your clients. So if, for example, someone, a lawyer asks a client, well, do you have Mr. Smith's contact information? And the answer would be no. Not, well, I have it in my phone. Would you like to take a look at it?
Right.
So I also admonish my clients to answer only the questions that are being asked. Make the lawyer who is asking you questions do their job. So if, for example, a lawyer asks, do you know what time it is? Don't say it's 11 a.m. You say, do you know what time it is? The answer is either yes or no. And make the lawyer then ask the follow-up question, what time is it?
Interesting.
Okay, so there's just little tricks like that. And I really do think it's critical that you spend time with your lawyer thinking about what the goal of the deposition is. What is it that you want to walk away with after your client is deposed, to make it a successful deposition? There's no winning or losing in depositions. There's no judge there. But you want to make sure that the answers you give are truthful, and are consistent with the story that you want to tell.
We're talking about depositions. We'll be right back right after this break with attorney Melissa Needle. Our Family Wizard is a leading app for more peaceful co-parenting. It streamlines communication and helps you avoid conflicts about things like expenses and scheduling, which we all know are two areas that are full of contention for many co-parents. On Our Family Wizard, you can do things like handle schedule changes, pay child support, and even send messages, which, unlike texts and emails, can't be deleted or manipulated. Plus, you can control how you're notified when your co-parent messages you. No more angry texts from your ex hitting your phone screen out of the blue. It's easy to see why Our Family Wizard is the #1 co-parenting app, trusted by more than 1 million parents and family law professionals. Learn more at ourfamilywizard.com today. We're back. I find this very interesting and fascinating about the deposition. So probably less is more is what we're saying.
Less is more, absolutely. And when I'm taking someone's deposition, I like to ask open-ended questions because I want to get the witness talking, chatting, and giving me more and more information. And then the information they give me leads me down another road. So it's my goal when I'm taking a deposition to get a witness to talk as much as possible. When I'm defending a deposition, it's my goal to get my witness to talk as little as possible.
Right. How often do you get to the deposition process? Like, what percentage of divorces? What would be a circumstance where you wouldn't maybe end up doing depositions?
If the case is not a high conflict case where information is well known between the spouses, and the parties are able to negotiate and reach a resolution because there's not too many complexities in the case.
Right. Okay.
Because depositions can be expensive. You have to pay your lawyer to prepare for the deposition or to prepare you to be deposed. If you take your spouse's deposition, they're going to want to take your deposition. The time sitting in the deposition, the time reviewing the deposition transcript. I mean, it does lead to additional costs.
And then also whoever else you're deposing, whether it's an expert witness or, like you said, a GAL or an au pair or a nanny.
Yes,
so those all cost.
Right. And oftentimes if an expert is disclosed, their deposition will be taken in advance, and not taking an expert's deposition in advance is a very risky thing to do. I won't do it. If an expert is disclosed by the other side, I feel it's critical to take that expert's deposition to understand what their expert opinion is going to be and how they arrived at that, so that I can formulate flaws and poking holes in whatever their evaluation or report indicates.
If you want to depose someone, is there a way, can someone say, no, I don't want to be deposed? If you want to depose like the expert or their spouse, can they say no?
They cannot, no.
Okay.
They have to submit to the process. They can file a protective order and explain the reasons why they don't think they should be deposed. But typically, it's very difficult to get out of a deposition. Again, if someone's trying to take your deposition just to annoy, embarrass, or harass you, that might be a reason. So
right.
If you're planning on taking someone's deposition there has to be a legitimate reason why you want to take their deposition. There has to be information that they have that you have a right to question.
You know, it was interesting. You said that one of the objectives also is to evaluate the witness that you're deposing and how they could be perceived if you had to go to trial. And I would think that's probably an important factor when you're dealing with narcissists, like we've talked about, that, you know, can really kind of disguise their behaviors. Speak to that a little bit. That second point that you brought up, where you're using it as a tool to determine, okay, how is this going to play out in court if it gets to that?
Yeah, it's very interesting. Whenever I represent a person who believes their spouse has either borderline personality disorder or narcissistic personality disorder, or tendencies of, even if they're not diagnosed, I always like to take their deposition to see for myself whether or not they fall into those types of categories. And you know, the narcissist will always try to charm you initially, and then there are questions and certain things that you can do to trigger them, and they lose their composure. I mean, it's fairly classic.
Things come out.
You know, if you have a skilled attorney, then they are able to do that. And so that's often, you know, one of the reasons, like I said, you want to see how a person behaves as a witness. That is often one of the things that I will try to do, is to see whether or not the witness will hold up under difficult, combative cross-examination. And you know, it's something that I think is very important to know prior to getting in front of a judge.
How long do depositions usually last?
Deposition could be anywhere from 10 minutes to 10 hours.
Wow.
Yeah. I mean, sometimes you take a deposition just because you want to get documents. So, you know, for example, you might subpoena a bank for certain records, and they will come to the deposition and hand over the documents, and you will authenticate the documents on the record, and it takes 5 or 10 minutes, and that's the end of the deposition.
Mm.
Now, where are these depositions usually? Where do they take place?
That's an excellent question, Wendy. Whoever is taking the deposition usually has the deposition in their office. So they'll happen usually in a conference room within someone's office.
So in court, how do you use the depositions? So you would ask the question and then they would answer, and then you would say, well, in your deposition, is that how it works?
I won't get into the technicalities, but very similar. Yes, that is exactly right.
So they're very, very important.
If someone testifies in court differently than they did at their deposition, then you can call them out on that in front of the judge, and they need to explain why their answer is different. And it is really a red flag to the judge that a witness is not credible if their answers are different between the deposition and the live testimony.
Very interesting.
It's interesting to me that you would. I totally get the notion of deposing either an expert witness, or maybe I'm even thinking like a forensic accountant, where it's probably something topically you don't understand. You don't want to get caught, if it were in trial, kind of, you know, wide-eyed. But if you don't know what you don't know, is it just I'm just trying to think of, like, as an attorney, how are you understanding maybe something that's far outside your reach of expertise when you're interviewing someone like that? You know, let's say a forensic accountant, and they're getting into things that terms and terminology that you might have never heard about. So how do you walk through that where you can get to a point where you kind of understand what they're saying, if that makes sense?
That's a fantastic question, Daniel. And depending on the complexity of the report, and it might be a custody evaluation, it might be a real estate evaluation, it might be an evaluation of a business. If it is a complicated report, then typically the best practice is to hire your own expert who can help you understand, digest, and point out the flaws in the other's report. And so for example, if it is a forensic accountant who has valued a business, I will hire a forensic accountant. I will provide the report that was generated by the expert to the forensic accountant that I have hired, and work together with that forensic accountant to formulate questions at the deposition to point out flaws. And I might even have to hire that forensic accountant that I've hired and then disclose them as an expert so that they can then testify about what their opinions are and what they think the flaws are in the spouse's expert report. So it can be very complicated because then once I disclose my expert, then the other side is going to want to take their deposition.
Right.
Which typically happens, and it is a battle of the experts. And that's why it's important that you hire a divorce lawyer who's very plugged into the community and can identify experts that not only are qualified, that's sort of a given, but experts who are well respected by the courts. Because the bottom line is, who is the judge going to believe? And so you want to make sure that whoever you hire to present your point of view is someone that is credible in the eyes of the judge. So it can be, very messy with a lot of different witnesses, but it can also be very important because valuation of assets or recommendations and opinions from psychologists about best interests of the children are all very important to outcomes in a divorce that have a long lasting effect.
It seems like it's very important, could be very costly, but you don't want to miss anything. So it seems like depositions are worth it.
Yeah, depositions really can help formulate a case and really are an important step in preparation. Is really the best way, I think, to understand why they're needed.
I think you gave us a really well-rounded view of what depositions are in our 8th of our 12th-part series, Mapping Your New Path Forward with attorney Melissa Needle of Needle, Cuda, Divorce and Family Law. Once again, thank you so much for this valuable information.
Always a pleasure, Wendy and Daniel.
Thank you so much. Until next time.
Au revoir.
Guidance that moves lives forward.